Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for
Hello, good morning. It's early here. It's 9:16. I'm only 1 minute late. Cellulite yoga pants, you're dark blue today. Beverly pink. Oh, wow. What a day. What a day. I'm so glad to be here. Vicky or Green, Nabel's here, Fargan. Let's get our color check in. See, oh, Adam's red. Get our color check in. We are going to continue on with the third and final part of this case. We are going to blissfully skip an hour and 10 minutes of argument between the lawyers about jury instructions. So if you want to see that, you can contact me separately. But I've made the executive decision that we are skipping that. We're going straight to the closing arguments. Then we will go to the verdict. Let's go. Why don't you guys tell me what you had for breakfast if you eat breakfast? I don't usually eat breakfast. I know, totally. Or lunch, yeah, it's probably lunchtime. Lunchtime? Anyways, let's travel by Floozy powder. Erica's back. This is the first sip of caffeine that I've had today. That was the second. I think I'm gonna need a stronger dose, to be honest. Let's go. I'm just impressed with myself because I actually took the time this morning to go through this and figure it out ahead of time. You know what I mean? And of course, it'll still not make sense to me now, but this one. This part of this video, hour 51 minutes, all rise. They fucking go on forever. Ever. And then finally we begin.
Instructions. You feel the need to ask the court a legal or procedural question that you drive operate. Yes.
On August 23rd, 2025, Matthew Arith got upset and lost control. He sucker punched his father-in-law, tackled him to the ground twice, and when his wife tried to intervene, he grabbed her by the neck and shoved her into a bookcase. He's now arguing self-defense, but there's no evidence to substantiate any or all of his claims. The state has charged the defendant with one count of assault in the fourth degree domestic violence, and that's an intimate partner count. That's the count against his wife. There's also one charge of assault in the fourth degree domestic violence family household member, and that's the charge against his father-in-law. In this case, the state must prove beyond a reasonable doubt both charges. This is a high burden, but doesn't mean beyond all doubt. The definition of assault is the same for both charges, and the only difference you're looking at between the two is one is intimate partner, and there's a definition in your jury instructions, and one is going to be family household member. I'm not going to read through all the jury instructions again, but as I go through this, I'm going to point you to different jury instructions and show you how the state has met its burden in the various parts. So the definition of assault is number 6. If you turn to that. And again, we're proving this in both charges, the assault against his wife, Andy Underwood, and the assault against his father-in-law. So an assault is an intentional touching or striking of another person that's harmful or offensive. This is somebody hitting somebody, somebody punching somebody, somebody tackling somebody. Now, if you look at jury instruction number 5, the one right before that, from the pages. To commit the crime of assault in the 4th degree, the state must prove 2 elements: that on the said date, the defendant assaulted Daniel Underwood and that this act occurred in Thurston County. You heard from Andy Underwood that her home is in Thurston County. You heard Thurston County Sheriff's officers responding to her home in Thurston County. That's not really in question here. The question is whether or not the defendant assaulted Daniel Underwood. So think about what you heard in regards to testimony on. You saw the photo of his bloody arm. You saw blood drops on the floor. You saw heard testimony from Daniel saying he was sucker punched and that he was tackled twice. You heard testimony from Andy that she watched him be sucker punched and tackled twice. You saw body cam from that day where Andy told the officer Matthew sucker punched him and tackled him to the ground twice. And that what you should look at too is that the testimony from Andy and from Daniel from that day, the day of the event, right after the event, and from today is very consistent. It didn't change after 5 months. It didn't change after 5 minutes. We believe that the state has proven beyond a reasonable doubt that Matthew assaulted Daniel by tackling him again, and by punching him in the face. Now, we don't need to prove all 3 things occurred. Any of those, just any harmful or offensive contact constitutes an assault. So if you believe that he was sucker punched, that's an assault. If you believe he was tackled just once, that's an assault. We just happen to have 3 instances of assault on that day to that victim. Now let's look at the elements of assault as they relate to Andy Underwood. Now again, instruction 4 here is specific to Andy Underwood. Number 1, that on this day, the defendant assaulted Andrea Underwood and that this act occurred in Thurston County. We already figured out this act was in Thurston County. So let's think again about the evidence that you heard regarding the assault on Andy. You saw body cam footage of her interview with Deputy Graves just after the incident about how when she was trying to pull the defendant off her father, the defendant then grabbed her by the neck, squeezed, and pushed her into the bookcase. Remember Deputy Graves testifying that her neck was red in person. Didn't really come across great here because the lighting was kind of crappy in the house. You know, he's sitting there with his flashlight trying to get pictures of it, but he did say that it was very red in person that day. Andy also told the deputy on that day that her neck hurt. You know, she could feel where he had put his hand and press against it. And Daniel testified that he saw Matthew with his hand around her neck, pushing her into the bookcase. I'd asked you also look at jury instruction number 9.
Look at
Sorry,
number
we're flipping
9.
around here.
Hi, Courtney.
To prove assault in the 4th degree domestic violence,
Ryan, here's the
state
thing. We are on the 3rd day of this trial. A lot of court is boring. If you find it boring, that's very normal. We like the minutia of court, and that's why we do this. But if it makes you feel any better, I cut out an hour and 10 minutes of exceptionally boring legal wrangling and yeah, anyways, once in a while I do cover body cams in members only, and I appreciate all the snarky comments. I'm just pointing out, like, this is actually a pretty exciting case. It's in front of a jury. We're getting like closing arguments from lawyers. Most of the stuff we watch doesn't have this. And Karen's and soft sits are probably better, yeah. Cool. That's the free will part.
must prove beyond a reasonable doubt that the defendant and victim are intimate partners. And this gives you a definition of intimate partner. So spouses, former spouses. So here they're technically spouses, they're separated, former spouses, it falls under intimate partner, Andy and Matthew. And it also tells you the definition of family household member, adults related by blood or marriage, father-in-law, son-in-law.
Did you just time him out?
So let's talk about the
Yoga
defendant's
John?
claim of self-defense. If you turn to instruction number 10, this is the self-defense instruction. Now, this is the one that I want you to read very carefully and consider the evidence very carefully. Second line here, the use of force upon or toward the person of another is lawful when used by a person who reasonably believes he's about to be injured in preventing or attempting to prevent an offense against the person. So if Matthew believed he was about to be injured or to prevent an offense against himself, and then there's an and, so that means you have to satisfy both of these. The second part after the and is when the force is not more than necessary. So let's think back to the two instances here. We have the assault on Andy and the assault on Daniel. Let's go first with the assault on Daniel. Daniel says he sucker punched him. Andy confirms that he sucker punched him. Both of them said that there was no provocation by Daniel whatsoever to Matthew. He didn't step towards him. He didn't put his fist up towards him. He did nothing to provoke an attack. Go back here. It's lawful when used by a person who reasonably believes he is about to be injured. There was no provocation here. There was no movement by Daniel's part towards Matthew. There were no steps towards him. He didn't gesture towards him. There's no evidence that you have that any of that happened. And then when the force is not more than necessary. So think about what force it would take to then sucker punch somebody. You're punching somebody out of the blue. They would have had to punch you first. There was no evidence that you saw of Matthew being punched first. You heard testimony that he was tackled to the ground, that Daniel was tackled to the ground, not once, but twice. And yet you heard no evidence that anything happened prior to that, giving rise to the defendant thinking he was about to be injured on either time that he was tackled flat to the ground. They need to provide that evidence, and they did not. And again, think about the second part of that, and the force is not more than necessary. What kind of force would you need to see for the defendant to be able to then tackle somebody flat onto the ground and claim that self-defense?
Ryan, it's a discussion, and I actually enjoy the discussion. Nabel's just bringing up her counterpoint to your point. That's how discussions go. Nobody's insulted. Don't worry. I'm trying to let this go because we have like 2 hours to watch today. That's why I started so early, because I also have a real job after this.
You didn't see anything along those lines. They need to present that evidence for you to buy into the self-defense argument. If they don't present that evidence, there is no self-defense. I would also argue that when you're thinking about the defendant's claim of self-defense, think about the whole story that the defendant told you. Consider if it made sense given the evidence presented today. You saw photos of the injuries on Daniel. You saw the blood. Think about the testimony you heard. Consider the description of the defendant's demeanor that day, as described by Daniel and Andy the day of the event. He was swearing, he was screaming, he was furious, screaming over and over, obscenities to the point where they had to remove the 3-year-old from the home because it was just an uncomfortable situation for her. Not a good situation for a child to be in. Consider his state of mind. Andy had just served him with divorce papers. Those papers were sitting there while they were out of town all week or for a couple days. And he's just sitting there stewing over the divorce papers in a home where he no longer resides. Now consider what he didn't do. He got notice that they were on their way home. He didn't unlock the door. He didn't open the door and, run to his 3-year-old child that he hadn't seen. He knew they were coming. He didn't respond to his wife's multiple attempts to get in the house. He sat on the couch. Consider Andy's testimony regarding his reaction to the scab on his daughter's knee. His story today, suddenly he's accusing her of abusing the child every time she goes out of state with the child. This has not come up before. This has never been mentioned. It's never been mentioned to the police. It's never been mentioned to anybody. There's no evidence for it. Consider the defendant's claims that Daniel had him in a chokehold twice. In one breath, he's saying Daniel has him in a chokehold twice. And in the next breath, he's saying, well, Daniel was out of breath and he doesn't have any, ability to do this. He didn't mention it to law enforcement. He never mentioned to law enforcement that he had been put in a chokehold. He never mentioned to law enforcement that he had been assaulted. And then consider the defendant's claim today for the first time that he had deep tissue bruising. Again, never mentioned that to medical professionals. Never mentioned any scrapes and bruises or cuts to medical professionals, to anybody. He claimed today that Andy was coming at him first. There's no evidence to support that. There's no testimony to support that. And this is coming out for the first time today. And then on the stand later, he claimed that Andy wasn't involved at all. He doesn't remember her being involved. When he was asked about putting his hands on Andy's neck, he said, I don't remember Andy being involved at all. So either Andy was coming at him, or Andy wasn't involved, or we're just creating stories out of nothing.
I don't know, but I'm gonna roll another joint.
Again, back to the self-defense claim.
It does not feel like
There
a
are
Friday.
two elements to this. The person has to reasonably believe he's about to be injured. It's the big one. In either of these cases, either with Andy or Matthew, think to yourself if he reasonably believed he was about to be injured. Andy was pulling him off her father after he tackled her father to the ground. He then grabbed her by the neck and squeezed. Is that force that is not more than necessary? Because that's what the law requires. I'm not sure how squeezing somebody's neck is force that's not more than necessary. Think about that when you go back to deliberate. Finally, I'm going to ask you to read part of jury instruction number 1. And listen to the microphone pick up while I'm flipping the pages up here.
She needs a iPad, right? Shouldn't she just have like an iPad so that she could just flick?
It says you as the jury are tasked. You are the sole judges of the credibility of each witness. You're also the sole judges of the weight or value to give to the testimony of each witness. This is your job to decide who's credible and who isn't credible. So think about which version of events makes sense to you and makes sense given the evidence presented by the witnesses. This was not an act of self-defense. All evidence indicates the defendant assaulted both his wife, Andy Underwood, and his father, Daniel Underwood. Now is the time to hold him accountable by finding him guilty of all charges.
Thank you. All right. I have a feeling that this is going to be a terrible closing argument. Allegedly, in my opinion. This poor lawyer, I feel bad for him because I don't think he was given very good facts to work with. And I guess it's like a slow week in Thurston County. This is what you are entitled to as an American citizen. You can request, if you're charged criminally, for a jury of your peers, and that's what he's done here. Even for any case that has jail time associated with it. So certain like traffic infractions, I've heard judges reject people's requests for a jury trial. But when it does hold the possibility of incarceration, then I do believe that it is possible to have a jury trial. Now, as a reminder, if you didn't see it, parts 1 and 2 are the previous 2 videos of this that we've done live. I'll put them into a playlist together and link them after this. Probably won't do that, to be honest. Maybe I will. I should, but I probably won't. But anyways, we did hear him testify and her testify and the police officer. So
6 minutes left in the time. Right.
also, I feel, oh, I'm sorry, Bill. I feel like sometimes I've been trying to lose weight and so that my belly doesn't look like his belly.
So basically,
So basically, let's just have a round of applause. Let's just have a round of applause for one moment, please. I have never in my life heard such a riveting opening. Oh, God. You know, it's always said there is a top of the class and a bottom of the class. He literally just said, we're going back 10 seconds, just let him go. Let him go. So basically, can we get a SBU command made? So basically,
to put it simply, what this is about is the physical contact, the physical fighting that took place on August 23rd of 2025. You've heard a couple of different versions of how that took place. It's your job to assess the evidence and make a determination of guilt or innocence based on what's in that evidence. And assessing that, in assessing the credibility of the witnesses, you're asked to avoid bias. The common bias that comes up in this type of situation is bias toward law enforcement officer, or bias toward belief of the testimony of law enforcement officers, or a bias toward females or against males in DV situations. I'm not saying that any of you have that bias, just you're.
oh my God. What is this? What even is this? Hi, I talk about Bruno. So basically, oh my God. Sometimes, like, things stick in my brain and then I say them an ungodly amount of times throughout my entire life. And so basically, is, I'm already feeling it worming its way into, like, a spot right in the top of my brain right now. So basically,
Asked to guard against such biases in making your decisions. The charges in this case are only accusations. It's based on basically 3 people's versions of the same chain of events. The officers didn't see any of the events as they took place. You've got Daniel and Andrea who were there, and you've got Matthew who was there. The fact that there are 2 witnesses saying one thing and one witness saying another thing shouldn't necessarily affect your assessment of witness credibility. You should consider the relationship between the witnesses and what they're saying, and the various motives that the witnesses would have to say certain things. Additionally, the arguments that we make as attorneys, mentioned campfire stories, I believe, at opening. The arguments that we make as attorneys are basically our summaries of the situations. And so what the prosecutor and I say up here is our understanding of the situation based on the evidence. You'll each need to come to your own.
So basically just erase that very practical closing argument that she just went through with you. Hi, Tin Man. So basically, I think he's high. I honestly, he's actually low, Rose. He's low. By the way, if you're just getting here, these are closing arguments. We've been watching this case for 2 days. This is a jury trial. So just keep in mind, this is his banging out. This is his, I gotta make a final impression. Oh my god, the sun's shining. Also, I feel bad for you, Bruno, with all the snow. Again, humble brag, I live on Vancouver Island on the Sunshine Coast. No, is it the Sunshine Coast? Regardless, I live on Vancouver Island, and there's no snow here. Knock on wood. We don't usually get any. So.
Understanding of the situation based on the evidence that you've received. It says each party is entitled to the benefit of all the evidence. So the evidence that was presented by the prosecutor, you might not feel supports the prosecutor's case. You might look at it and feel that it supports Matthew Arrett's case, and that is an absolutely valid way to assess that evidence. If something you see in the evidence looks fishy, looks contrary to what the state's arguing here, or what any of the witnesses has testified to, that's a valid concern, and that's something that it's in your wheelhouse to weigh. Furthermore, I mean, the decisions that you're making today, it's not a moral decision. It's not any sort of non-criminal acts. It's not about conversations or arguments that took place and whether words were used that you object to, or whether non-criminal decisions were made that we might find objectionable. That's not what we're here for.
Bruno, that's like a reverse catfish off of Tinder. He said it was 3 inches, but he showed up with 7. Most people don't complain about that unless you're talking about snow.
We're not here to make decisions based on sympathy, prejudice, personal preference. We're not here to make decisions to protect anyone from anyone else. The sole decision to make here today is whether or not a crime occurred based on the instructions and the evidence that you have.
So basically, would you feel good about paying this lawyer?
Go back to the page that was previously missing. It's either number 14 or 15, depending on how that looks. That's an instruction about each of you coming to an individualized decision here today. I mean, imagine if imagine if this was your trial and there were 5 jurors back in the jury deliberation room that were on one side and 1 juror that was on another. And it's getting close to the end of the day, and the juror's like, "Oh, let's just get this done." Would you want that 1 juror that was on your side to turn against you for the sake of just getting the case done, or would you want any of the jurors to abandon their belief in the evidence or their belief in the case just for the purposes of getting the case done sooner? We're just asking you to guard against that as well. Guard against any decisions that are based on frustration or the time of day or the inconvenience, because your role here is very important. The effects of this case on everybody involved are going to have long-lasting effects into the future, for you and for honestly the attorneys in the room and the judge. We're not gonna, once this case is done, it's kind of going to be done. For everybody else, I mean, this is a very serious decision, and we ask you to take it very seriously. That also goes sort of into the abiding belief language that's mentioned as the beyond a reasonable doubt. There was some mention that was made of if you have an abiding belief in the truth of that charge. Excuse me for a second.
Wow.
What abiding means in that situation is, again, it's not a hasty decision. It's not a decision that is made on the fly. It's not a decision that you feel like is a coin toss or something that's going to fade away, because after we leave here today, or after we leave here once the verdict is entered, we can't come back and take it back. You know, we can't, if you look back on this case in a week or a month and say, gee, I wonder if I made the right decision, it's too late for that at that point. And that's what that abiding belief language means, is whether, you know, whether your decision today is going to last, whether your judgment on these is so clear in your mind, again, beyond a reasonable doubt, that you're not going to look back on it at a later date and say, you know, gee, I wonder if I made the right call there. And again, all of these instructions are put in place to sort of protect everybody's rights at trial, make sure that the juries are, you know, considering everybody's situation essentially as if it was their own, so that everybody can be confident that everybody's getting a fair shake out of this process.
You were calling your wife a cunt, and you sucker punched your father-in-law after getting served with divorce papers and being pissed off about it. Put yourself in his shoes. Yeah, no. This is a terrible closing argument.
Turning to the situation at hand, I mean, it sounds complicated. It sounds like there's a lot going on, but it's ultimately very simple. There was a fight between Daniel Underwood and Matthew Arith. The question really kind of comes down to how that fight started. And then at some point, Andrea intervened. There's a question of whether Matthew attacked Andrea individually and initiated a physical contact with her, or whether she intervened in the physical fight that was happening between Matthew and Daniel.
No, Tattoo Neck
And,
Girl was like last week.
You know, whether there was some intervention there. And that's really what it's all about. The assault itself is physical contact. That's the nature of the charge. Self-defense is basically, you know, who was threatening who came at who. But as far as the assault itself is concerned, that's basically just about the physical fight. It's clear that the atmosphere in the house was tense that day. Matthew testified that he was out working in the yard, came in to shower. He knew they were coming home from Long Beach. That's not an argument. They were driving home, 3-hour drive approximately, stopped for lunch, came back to the house. The door was locked. Andrea was knocking on the door, banging on the door, as she said. Matthew came out of the shower. Nobody argued that he came out of the shower. He came out of the shower. He had a towel on. He went to put some clothes on. Everybody knew that the family was going to be there, and he felt it was inappropriate to be, you know, in a towel in front of his family.
Yeah,
and well,
so
obviously that wouldn't necessarily apply to him and Andrea because, you know, of their previous relationship. However, when it comes to the extended family being there as well, you know, Andrea's mother wanted to come in and use the bathroom, things like that. He wanted to put some clothes on.
We all want to put
Both
some clothes
Daniel
on
and
and then
Andrea
let our wives
mentioned
crawl
parking
through the
situation.
window to get into the house. Hi, Casey Carey. Yeah, I literally have to roll this joint right now because this is hurting my head. This is hurting my head. But by the way, just in case you're thinking, oh my God, she's gonna drag this out for another day. I'm not. We're gonna get a verdict today.
Being parked in the middle of the driveway. Matthew testified that when they came in, that was the sort of the initial conversation, that the door was locked and the vehicle was parked in the driveway, so they couldn't park in the driveway. And that started basically the argument. There's no denying from anybody that there was an argument.
Oh, Thank you so much, Nabel. You are so sweet. I appreciate you so much. Thank you for the PP. That is so sweet. And I love you guys too. I appreciate you.
Was taking place. Andrea came home, door was locked, had to park, up the street because the driveway wasn't available. Daughter had a scraped knee. Matthew noticed that, confronted Andrea about that. The argument continued. The words, I'm not going to repeat them, may not have been terribly, it may not have been an argument that any of us would have wanted to participate in. There was some disagreement as to whether the argument took place in front of the daughter. Andrea stated that it did, that he was insulting her in front of her daughter. He was stating that, that they had a rule not to assault each other, or not to insult rather, each other in front of their daughter. And based on the conversation and the nature of it, that was when Andrea took the daughter out of the house. The divorce was filed earlier that week. Matthew was in the process of looking over the paper. So all of these things are going to be sort of hot button issues for these conversations, for these arguments. And the arguments.
Damn! I approve! I approve, Bruno. Yes. A day drink? Cheers! Mine's just an energy drink, but I'll join you later on after my personal chef shift is over. I am a personal chef and a pastry chef. I make delicious pastries.
The testimony that was given by Andrea and David was that they came in perfectly calm, cool, and collected, and that Matthew was the one to just completely go off the rails. But based on our own experiences and arguments, how often is that the case, that one party, that one person is just, completely just off the rails, and the other person's calm, cool, and collected? Matthew's testimony was that both parties, or that he and Andrea were yelling at each other, that it was going both ways. And I mean, that just seems more consistent with how arguments happen. So, and part of what you're asked to consider is kind of what makes sense, based on your own life experiences, looking at the evidence that's presented and weighing it. I mean, what makes sense in this situation? Does what one witness said make sense in the context of your life and experiences? What another witness said, and that's in part how that credibility is gauged. So when you're weighing the testimony that you've heard, what makes sense here?
So basically, what makes sense here? I think 4 eggs.
And this again is all before any sort of assault happened. They all said that there was no assault that took place until Daniel came to the room, and that the initial physical contact was between Daniel and Matthew. So everything that took place as to the assault, it provides context, but it isn't necessarily relevant to the guilt or innocence in this situation. And it may be objectionable, which again goes back to why this might not be a moral decision, why it's not a moral decision, but a decision of law. Some of the things you've heard are offensive. I can assume that there are probably many things that we didn't hear that would be offensive, potentially on both sides. And again, it kind of goes back to everybody's experience. There were some interesting things that were said as well. There was some conversation about a six-pack, abs, physique, things like that. They were saying that it was a very aggressive situation.
Very aggressive situation about his 6-pack, and he didn't have one. So basically, didn't you see how fat he was? Oh my god. I actually am thinking about making homemade marshmallows as one of my next projects. again, I'm always deciding to make something from scratch for some reason, and I just like to do it. I don't know. I like to do it. I like to choose hard mode.
A very angry situation, and yet there's some levity, some joking around going on here as well. Andrea at some point told Matthew to leave. From a legal standpoint, I mean, they both legally owned the house. He wasn't under any real obligation to leave. He had been served divorce paperwork and he wanted to talk. The conversation had obviously turned a little weird, but he wanted to talk through it. Then whether he was called in or came in of his own volition, depending on the testimony, Daniel came in to break it up. He'd heard the argument going on.
I'll be right back.
And he came in to break up the argument. Based on Matthew's testimony, he had made prior threats to Matthew, and Daniel knew of prior arguments with Andrea based on his own testimony. So Daniel had a bit of background here that would influence how he came into the house. Again, Andrea and Daniel want you to believe that he came in calm, cool, and collected, but he mentioned himself, paternal instinct. If somebody is threatening one of our children, or if somebody's in an argument, in a loud argument with one of our children, how do we come in? Do we come in like, oh, hey guys, what's going on? Or do we come in like, hey, and start, more sort of assertively, you're trying to intervene. So, I mean, basically that's what makes more sense.
I went through a complete phase, Captain Snarky, of watching all these videos of like large scale kitchen productions in the military. I literally went through a weird phase where I was obsessed with military rations. And one of the most unique gifts I ever got was a German, I think it's EM. Anyways, the German MRE, the guy I was dating at the time, I don't know how he got it. He traded it for something from somebody else that he knew was in the military. He wasn't in the military. But for my birthday, I opened up this expired, mind you, German MRE, and I was just like so enamored with it. Of course, Courtney knows my love for Steve MRE 1989.
Here is that Daniel came in hot, came in aggressive, and then that's where the testimony starts to differ. If Matthew believed that Daniel was a threat to him, if Daniel came in a threatening manner, then the self-defense would stand. If Daniel initiated the fight, if Daniel was the one, as Matthew testified, to put his arm around his neck and put him to the ground, then Matthew's innocent of the assault. He did not initiate that physical contact. If Andrea intervened with the physical contact, and as part of that was pushed off, and physical contact was made there, then that's not a knowing or intentional assault. That's somebody intervening in a fight that's already going on, and somebody out of reaction or whatever, just sort of pushing other people away. That's not an intent to harm or offend. That's just the nature of wrestling around. And that's the consistent part in the testimony, was that there was some wrestling around, that Andrea sort of intervened with the situation, even that it broke up at one time, and then there was more wrestling around. And some of the external evidence that we can look at to sort of gauge this is what's in that video. The officer, the Andrea, Daniel, and Matthew described this really chaotic situation. Matthew in the video is clearly disoriented for whatever reason, whether it was through injury, through some medical ailment, or what have you. The only officer that testified to anything about alcohol being involved was Officer Wakefield, Deputy Wakefield, and he testified that the odor was slight with no other information about drinking, no questions to either side about whether there was alcohol in the house, whether there were open containers found anywhere, no evaluation of whether Matthew had drank at all, no questioning of either side about whether Matthew had anything to drink. So there's no other evidence to prove any sort of alcohol consumption in relation to this. There is, the hot day, the possibility of head injuries from wrestling around, and the chaos of the situation. But the officer, the other deputy that testified mentioned that when he came in, the people were flustered, that it looked like Andrea had been crying, that there were injuries. They took photos and videos and those things. But the demeanor in those videos is not the demeanor of people who have been in this type of situation. They were very calmly discussing the situation. There wasn't really a whole lot of emotion in those conversations, which makes one wonder if the situation was exactly as it was presented.
Mr. White, you have 1 minute left in your time.
Just to make it really quickly here then, also look at the photos. The photos of Andrea don't show any proof of injury to her neck. The photos of her dad, he said he was punched in the jaw, sucker punched in the jaw. There's no photos of any sort of injury to the jaw. So we'd actually consider that. That suggests that maybe the punch didn't happen. Maybe the fight did start as more of a wrestling situation. And maybe, Daniel did come in hot and initiate the thing. And I'm saying maybe a lot because that's for y'all to decide. Like I said, we stood up here, we heard 3 different stories from 3 different people.
All right, let's
And-
wrap it up.
Yeah, sure. Basically, if you don't know, what the story is or can't make a determination as to guilt, then you have to find Matthew not guilty. If you believe that Daniel started the fight and that Matthew was acting in self-defense after Daniel attacked him, then you have to find Matthew innocent. So we just ask you to consider all the evidence and all the information. I'm out of time here, so again, we'd ask you to consider all that and suspect that when we come back and find Mr. Arith innocent of all charges. Thank you.
Thank you, Mr. White. Mr. Predican, you have 6 minutes left in your time.
I'm sorry.
Oh,
Yep,
she's
6
got
minutes
6
left.
minutes left to redirect. I'll let that happen here. That was possibly the worst closing argument I've ever seen. He would have been better off coming up to the stand and saying, ladies and gentlemen, the task before you is very simple. You need to find him not guilty because they didn't prove the elements of the crime. The fight was mutually started, and there's no evidence pointing otherwise. I thank you for your time. That is all. Like, that literally would have been better. Would have been better. So basically,
It starts when I get up there, right?
Oh, I'm already started.
Okay. In that case. What you need to remember, what the lawyers say is not evidence. What Mr. White is telling you right now is not evidence. His
Don't worry, he
claims
didn't
that
make any
maybe
sense.
Andy and Daniel made up this whole situation or made it worse than it needed to be, or maybe they didn't have the right to meet, that's not evidence. The evidence is the facts that you saw, the pictures that you saw, the body cam that you saw, and the testimony that you heard. That's what you need to rely on. You don't need to dig in your brains and conjure up some situation that might have happened. We know what happened. You had Andy telling you what happened right after it happened. You saw the body cam. She detailed it exactly. She then came here and told you exactly what happened again. And it was almost identical after 5 months because she remembers it because it was a very traumatic event for her. Daniel said the same thing. He's testified to almost the exact same thing that happened. These are not people that are making up this situation, but you need to determine that for yourself. Think about the evidence that you heard, not what's coming out now. Mr. White is throwing out things at the last minute. Maybe they're biased against him. Maybe, he had a head injury. Maybe Matthew, drank too much that day. Maybe he didn't drink. We didn't, maybe there were open bottles there. Maybe he had heat stroke. That's not what's important here. What's important here is the evidence that actually was presented. That evidence shows that there was an assault that happened. The assault on Daniel, the assault on Andy. There is absolutely no evidence that you got of self-defense. And remember, it's not self-defense that you and I would think of self-defense. It's self-defense according to the legal definition. Okay, the two-part legal definition there. And if you go back to your definition, it needs to be preventing an offensive attack and not more force than necessary. You had two witnesses that told you they made no aggression towards Matthew at all. And yet Daniel was tackled flat to the ground twice. It would have to be proportional. He would have had to have tackled him first in order for him being tackled back to be a proportional reaction. He would have had to punch him first for the punch back to be self-defense. Think about Andy's situation. She is pulling him off somebody and he grabs her by the neck and squeezes. What does that sound proportional to for you? How does that become self-defense? Squeezing someone's neck and throwing them into a bookcase does not sound like self-defense to me. Just want you to look at the evidence, the facts that you have, not anything Mr. White said at the last minute, but the facts that you were given, the testimony that you heard. And I believe that you will come to a guilty verdict on both charges of assault.
Thanks, Ms. Brickman. Folks, for the closing argument, you've had the instructions, you've heard all the testimony. You will go back to the jury room with the verdict forms, with 3 photos and with 2 thumb drives that have the body cam videos on them. And actually we'll turn on the television and show you the USB port for the thumb drives. When you reach the verdict, let us know. Juror number 7, you're not going back with them. We have what we call alternate jurors for trials that last more than 1 day in case somebody doesn't come back for whatever reason. We cannot get a jury verdict unless we have 6 jurors. So we have 7 participate, and juror number 7 has unknowingly volunteered to be our safety valve in this case. So I want to thank you, but you just stay where you are and we're going to send the other 6 back and we can chat. If the remaining 6 will head back to the jury room, Ashley will bring you the exhibits. And when you have a verdict, just let Ashley know and we'll reconvene everybody.
It's always Ashley. There's got to be 1,000 Ashleys. And it's a joint, not a cigarette. Also, we don't really need to watch this part.
1 and 2,
I will tell
number 2
you.
is-
No, I won't. I won't.
Please be
I won't
seated.
even tell you about it. Number 5.
All right, what are your thoughts on not getting to go back? Is the language,
Oh,
if after
shit.
full and
Now
fair
I wanted to
consideration,
hear that. What are your thoughts on not getting to go back? Because I would be pissed as fuck. Now I gotta go back and listen to that. Damn it. Damn it, Judge. You're ruining the vibes.
I don't know if you left your phone number with Ashley, she can call you with the verdict, come in and even, I really reconvene everybody. Folks, for the closing argument, you've had all people like you and the other members of the jury who say something they won't be published.
Publish?
Find someplace else to be. Means, so find a park and just walk around.
When do you get the boot off?
'Lobby, I guess. The concerns
We still actually have surges to get matures, so. Well, yeah.
When did you break it?
It's possible.
Ugh.
Okay, interesting. I guess I'm not gonna listen to it because I can't really make sense of it. Let's just get right to it. Nothing to it but to do it. Let's hear the verdict.
That's the language. If after full and fair consideration, of the evidence, you are not in agreement as to the answer, then do not fill in the blank for that question. It's on the special verdict form. Obviously dealing with
I
the
believe the
issue
wife.
of an intimate partner or family member. And the question is, can this be our choice on one of the counts? So,
I don't understand.
yeah, I'm not sure
So the jury's asked a question.
I think what they're saying is they are not in agreement on one of the counts as to the status of one of the victims. That's what it appears to me. And there is in the instruction, it says, if you can't be unanimous on yes or no, then don't fill in the blank. And
They're not in agreement about the charge itself or about the DB tag?
Just for clarification about what the question means, because I think it's unclear.
Okay, so I think it's pretty clear. It's in the instruction on the special verdict form where it's asking, is it intimate partner or is it family member? And then after that, and it says it's either unanimously yes or unanimously no.
Well, and I think we need to just
And then
point out that once you've fucked, you are always intimate partners. Just because she left him doesn't mean that he doesn't get designated as perpetrating violence against his intimate partner. The question I thought was being brought up was, is her dad a household member? Because I don't think he is. He might be an extended family member, but I don't think he lives in that house. So I don't think there can't be any question that she is his intimate partner or was. Just because somebody isn't with somebody anymore, and let's say that, like, separate case, that person perpetrates violence against that person after they've cut that relationship off. That doesn't mean because that person cut the relationship off that they are no longer intimate partners in the lens of the law in terms of that crime.
It says, if after full and fair consideration of the evidence, you are not in agreement as to the answer, then do not fill in the blank for that question. And they are asking, do they have permission to do that? And the answer would be, of course, that's what they've been instructed. So are we in agreement on that? I don't see any other answer to give them.
Don't see why they couldn't. Yeah, I mean,
Yes, so, Your Honor.
I'm sorry?
I guess so, yeah.
I mean, that's what they were instructed.
What-
That's what the instructions are, so. Next. You guys don't have anything to do?
What?
Very exciting.
No, we're watching court, Judge.
6, I'm sorry. I'm assuming.
All right,
Very
all
exciting.
rise.
All rise. Please be seated. All right, folks. I'm assuming there are verdicts. And juror number 5 is the presiding juror. If you would rise or 6, I'm sorry. Juror number 6, if you would rise and read the narrative portion of each of the verdict forms, please.
The narrative.
Yes, we, the jury.
Before you do, I want to address. So, Del, my whole point is that what I think is that once you've been an intimate partner with somebody, it always qualifies for that designation. A partner, an intimate partner or former intimate partner is its own separate designation in terms of the law. So yeah, if you happen to perpetrate an offense against your ex-wife who you divorced in 2000, regardless if it's 25 years ago, that's a former intimate partner. And I would argue for the intimate partner designation. But, oh, and Chuck, pay meds and bed rest for a bit, but you're home, that's so great. But yeah, like in this particular case, very recent, within months or weeks of filing for divorce, I wouldn't think there's any question about this. They have a small child together. I mean,
So count one, we've left it blank.
Okay, as to guilt or innocence or not the special verdict form, the verdict forms.
Verdict,
Okay,
okay? Then for verdict two, we, the jury, find the defendant Matthew Wayne Erith guilty of the crime of assault in the 4th degree as charged in count two. And then on the second sheet, we answered yes. Want
okay,
me to read the whole thing or?
thank you. And I'm gonna send Ashley over to pick up the verdict forms from you and I'll take a look at them.
Okay.
I hope his lawyer isn't his divorce lawyer. So guilty. Guilty on that assault charge. I'm not sure what happens next here. My point, Paul, is of course they're former partners, but the second you perpetrate violence on them, that to me indicates that there's still something there because of that former intimate partnership. As long as you don't commit any violence on them, they're your former partner. Nobody's worried about it. My point is that if you're accused and found guilty of committing violence against a person that you were ever once intimate with, I believe that should have the designation.
So I think what's happened here is we have a hung jury
Because you
on
don't-
count one.
Hung jury, what? Also, you don't have to be married for it to be an intimate partner situation. That's the whole point. You could be intimate partners because you slept together. You could be intimate partners for other different kinds of reasons, because you're married, etc. Oh my God. Let's continue.
And we have a verdict on count two. So I'm going to ask all of you a few questions, and I will do that in turn, the same questions for each person. So as to count one, juror number one, better get my pen so I keep notes here. Is it your belief that if given more time, the jury could reach a verdict, unanimous verdict on count one, which has no verdict at this point?
No.
Okay.
I don't.
Juror number two, juror number three, juror number four, juror number five, Juror number 6. Juror number 1. Is the verdict of guilty on count 2 your verdict?
Yes.
And is that also the verdict of the jury? Meaning all 6 of you agree?
Yes.
Juror number 2, is this your verdict? And also the verdict of the jury?
Yes.
Juror number 3, is this your verdict? And that of the jury? Number 4, this is your verdict? Well, all 6. Juror number 5, is this your verdict?
Yes.
And that of the jury? Juror number 5, it's your verdict. Juror number 6, is this your verdict? And the verdict of the jury? Juror number 1, the answer on the special verdict form to count 2 is yes. As a family or household member, is that your verdict?
Yes.
Okay, and it's your understanding that's the unanimous verdict of the jury.
Yes.
Juror number 2,
Yes.
juror number 3, juror number 4, juror number 5, juror number 6. Yes. All right. I will enter finding of guilty based on the jury verdict on count 2 and declare a mistrial on count 1. And folks, at this point, you are going to be free of any prior instructions that I gave you in this case and any further obligation in this case. The state will have the opportunity to make the choice as to whether they wish to refile count 1 and proceed at some later date on that count. But with your indications to me that there's no likelihood that you would reach a unanimous verdict in this case, we just have to declare a mistrial on that charge. And that's doesn't mean you did anything wrong, it just means there's no verdict in the case. So that's where we are. So we will proceed on count 2 today, and we're going to go to sentencing here in a couple minutes. You're welcome to remain for sentencing since you've been here all day and here yesterday as well. You don't have to remain if you choose not to.
I think count
And
1 was
you all
the
have
assault
expressed-
on her, and count 2 was the assault on the dad. Or it might have been the other way around. Basically, I think they found him guilty of one of the assaults, but not the other. Confusing verdict for sure. Also, I guess we'll watch the sentencing, shall we? This will be an appropriate time to continually say next to get that dopamine hit.
Or some version of it, how busy you are, and I truly appreciate that outside of your obligations here with the court. So we're going to proceed on count 2. Regardless, I want to thank all of you for responding positively to the juror summons, showing up, and to spending 2 days with us, second day, really long day.
Those are
And I
rookie
really do
fucking
appreciate-
numbers, Judge. Yes, yeah. That's how I feel too. We don't need all the pandering, to be honest. We don't need the pandering. Stop meandering.
You may be seated. And Ms. Pritikin, state's recommendation by way of sentencing on count 2.
Life. I'm joking.
Would we be able to hold over sentencing and
We can,
given the late hour and
well, give me some idea of the basis for that request other than,
just time to process with the victims and
yeah, with the mistrial on count 1, I don't think that there's any other any other process here. We have a conviction on count 2. I think we should go to sentencing on count
Right
2.
now,
Yes.
the state would be asking for 20 days in custody, DVE and treatment, mental health evaluation and treatment, substance use evaluation and treatment.
Thank you. Mr. White?
Your Honor, defense first request be that any sentence imposed today be stayed until we figure out what, or any custodial sentence that is imposed today be stayed until we figure out what's going on with count 1, whether the state's going to refile that to the extent that any sentence could be run concurrently between the 2 counts if that case results in an eventual conviction. With regard to the domestic violence evaluation, the circumstances that seems fair. Mr. Arith and his wife, Mr. Arith represented that he and his wife have been involved in domestic violence, or not domestic violence counseling, in couples counseling for about a year and a half with Olympic Council. But
And
I
it's
think
obviously
that
been working so
it's
good.
probably to the extent that the court would consider that or consider any part of that throughout any sort of domestic violence evaluation or treatment, we'd ask the court to do so. I don't believe there's enough proof of any sort of substance abuse in this case. There was no testimony to that except for by Officer Wakefield, and he's described the alcohol odor as being slight, which would suggest that there's a possibility that either alcohol didn't necessarily have an effect in this case, or alcohol may not have been present at all. Additionally, Miss Underwood testified that she testified she didn't recall noticing an odor of alcohol on Mr. Arith, but she did speculate as to whether or not there was any alcohol in the conversation with the officer, but she didn't note any basis for any sort of suggestion as to why that was other than the behavior. As the mental health evaluation, Mr. Arith clearly at the time that this happened was confused throughout the process. However, says that the separation and the time since this case or since this incident took place has worked well for him mentally and physically. He's looked into the possible glucose issues with regard to the hypoglycemia. He's changed his diet and his lifestyle, and I believe that his presentation here in court has been drastically different from the presentation in the evidence of the case. So I don't know that a mental health evaluation would be necessary or warranted. So we'll defer to the court as to any sort of evaluations or treatment, obviously. He already did 2 days in jail for this, so he's got credit for time served. The primary, well, I guess the one count here that we have a guilty verdict on was not related to, I shouldn't say not related, that sounds weird. Was a fight between Mr. Arith and his father-in-law. It was not a fight necessarily between Mr. Arith and his wife. There was testimony that they had not had, physical issues previously. And this case is now 4 or 5 months old without incident, no prior incidents, no prior history of DV. I don't know that any additional jail time would be warranted in this case. So we're asking the court to suspend any jail time. If the court doesn't post jail time, again, to stay that and then to consider Mr. Arith's financial ability to pay any discretionary fines or fees, Your Honor.
Thank you. Mr. Arith, anything you'd like to say?
Oh, I wouldn't, sir.
Currently we are going through a divorce, and jail time would impose a significant stress on myself and Andrea. We still have bills together.
You don't think she wants
and
you
each
to go to
other's-
jail, bro? Were you not here? Are you fucking kidding me right now? What? Wow. That's actually weird. That's very weird. He's naming her as the reason he shouldn't go to jail? Oh dear.
names, and um, it it wouldn't be practical for either of us. We both need to work to continue paying paying bills. As and like as mentioned, Mr. White, I have dramatically changed my lifestyle and eating habits, and I have completely fixed the my glucose blood sugar issue.
And I have a
Um,
6-pack.
And um, that has never happened since, and will not happen again.
How did that factor in what happened on the 23rd?
I was trying a new diet, and it wasn't working for me, but I have
I'm
adjusted.
sorry.
I was trying a new diet, and it wasn't working for me, but since then I have adjusted.
Okay. How did it impact what happened on the 23rd of August?
Obviously the stress of divorce. Not seeing my kid for 2 days. I saw her almost every single day up until that point, and now I haven't seen her for nearly 5 months. It's been devastating. But stress, the heat. I was working outside that day. Um, I'm still claiming self-defense. I was attacked in my own home. And just the stress and the chaos going on, it took a lot out of me when I was already low on glucose. And that's why I didn't look 100%.
Your Honor, the victim would like an opportunity to speak at sentencing.
Let's just the state which victim they're referring to.
Victim on the charge that the guilty victim.
Understood.
And Mr. Underwood? Go ahead and have a seat. Right there. The device in front of you is the microphone will record your voice, so that's why I wanted you sitting there.
Gotcha.
Okay.
Everything
So
Mr.
he's
Arith
the victim.
is
So they
saying is
believed the charge against the father-in-law, but not against the wife. Okay. Sorry, dealing with something else.
utter nonsense. Everything that has happened and that happened that day was all due to his lack of respect for his marriage. He states that he wants this to go through and because he's helped paying bills. Well, he has not paid one rent since for the last 3 or 4 months. My daughter has been paying all the bills, everything that regards to his business and the machinery that was done has been paid by my family because he hasn't paid a dime. He has not paid a dime for his daughter since this all started, since probably May. He is not doing his responsibilities as a father. He's not doing his responsibilities as somebody that wants to co-parent into the future. He is hiding. He is hid from everybody that's tried to serve him he says he's retaliated on, how he was eating and everything like that. But I mean, he's still drinking. He's still going through that. He still gets angry. He sits there and will say stuff, around to his family and everything, that everything is fine and dandy and he's doing great. But what he says is not true. He has not reformed himself. He is not a different kind of man.
So there's been a protection order in place since August. I'm assuming you've not seen Mr. Arith during.
Correct.
And I think his daughter was also protected in that order, so he's not had the legal ability to see
Correct.
his daughter. Okay, so what you're talking about is prior to that, or what
Well-
are you saying that he? Clarify for me what you're saying about Mr. Arith not acting responsibly toward his daughter.
He hasn't paid a dime for anything that his child needs.
Okay, so financially you're in.
Financially, yeah. I get that he hasn't been able to see her and stuff, but it doesn't stop his responsibility and making sure she's well taken care of. He hasn't even put out the effort to do it. I mean, even a token amount. He has just pretty much ignored any obligation that he has to his child.
All right, thank you.
If we may just provide some additional information with regard
Good.
to that.
Hold on, Mr. Yeah. Right, and Mr. Underwood, were there any ongoing medical issues with the injuries as a result of the assault in this case?
I had 3 months ago, I had a hip replacement.
Can you blame it on the assault, or
I'm sure that over time that I probably would have had this done, but due to the way I was, pushed down onto the ground and stuff on my hip, I mean, I could hardly walk the next day. So my surgeon said if he could have got me in the day he saw me, he would have.
all right, thank you. Mr. White, you had something else you wanted to add?
With regard to any sort of marital or household obligations, the divorce case in this case is still going forward. There have not been any, there hasn't been a structure put in place for Mr. Arith to abide by those. There have been no contact orders with the people that he would be communicating with to provide any financial support. There's also a risk that provision of that support could potentially be construed as some sort of third-party contact or inappropriate. So, I mean, despite, I understand what Mr. Underwood's saying, I respect what he's saying. But I think that Mr. Arith's ability to follow through with those obligations, since the protection orders were put in place at the beginning of this case, would have been somewhat limited. Additionally, with regard to the protection orders, I guess we'd like to know which ones stand and which ones wouldn't at this point. And then with regard to any injuries, we just ask for, if the court's considering restitution at this time, we just ask for a hearing for any restitution in the case.
Thank you.
Additionally, I guess one other thing, if the court is considering a restraining order for the daughter, there is a temporary restraining order that's been requested in the Superior Court. I don't know if that's been put in place in the family court. So we'd ask the court, at least with regard to the child and as it relates to this case, if the court is considering leaving that protection order in place, to terminate the order with regard to the child and defer essentially to the family court to sort out that, as there is a parenting plan that's being decided on and discussed and adjudicated right now. And it would be really more in the purview of the family court to determine whether, when, and how Mr. Arith should be able to have access to his daughter.
Your Honor, the state would strongly request that the no contact orders with both Andrea Underwood and the child stay in place. This case is still predisposition for charge 1. and the state plans to refile.
I'm trying to get the judicial information system operating, but my guess is they're working on it. I'm not expecting anybody to still be in operation at this hour. And so it's not giving us access. My recollection is that there were 3 no contact orders entered by Judge Meyer to Raymond.
Correct.
One for each party.
There are 3 no contact orders, correct? They were entered, the arraignments were a little staggered because of the name difficulty. There was the initial police report contained the name of his brother. And so the no contact order was not initially entered until that was corrected with a corrected supplemental police report. So the initial arraignment for count 1 contained the no contact orders for Andrea and the daughter. And the following arraignment about a week and a half later, for count 2, contained the no contact order for Mr. Underwood.
Right. So of the 3 existing orders prior to the trial today, do they all protect Andrea, the daughter, and Mr. Underwood? Or do they, one protects
One
Andrea
protects Mr. Underwood, the other one protects mom and daughter.
but there are 3 orders.
I believe there's an order for each of the individuals, just based in part on the way the case was filed. As I recall,
I'd be checking the same system that you did, that's
Which
not
is-
up and running.
as I recall, the protection order for the minor was, the 3 orders were not entered sort of contemporaneously. And
Okay,
this is
but
just-
all I need to know is what's the status of the 3 orders?
They're all active,
I mean,
all correct.
right, but who are the parties on them? That's my question.
I believe it's one for each of the.
One for the minor,
one
one
for
for-
Miss Underwood, one for Mr. Underwood. and-
Currently,
And
Because of the way that things have been kind of called to
Oh, okay.
order.
Ms. Pritikin, I
Yes.
don't have any protection order submitted as a PDF for potential post disposition. Your office hasn't submitted any protection orders.
I think they were planning on this case to resolve during office hour times
And-
and that they would do it on the fly while the office was still open.
Okay,
And Mr. Arif wanted to respond to some of the things Mr. Underwood was saying, Your Honor.
Your lawyer can't even convince you to
we don't
shut
need
up.
to have a mini trial here.
Understood.
I just want to clarify some falsified information.
Oh, MB, you will be what proceeded here today is possibly one of the worst examples of closing arguments we have ever seen. Ever. He began with so but or what did he say? Is that what it was? So but or so but actually, or actually I can't even remember now. SBU, USB, I don't know. So basically that's what it was. So basically and he's melted my brain subsequently. It was terrible arguments. I hope that this lawyer is not his lawyer for his divorce.
Yeah, a lot of it, what was said is outside of my responsibility as the judge in the criminal trial, and it's more a family court issue, and it may be very relevant to any ongoing issue in family court.
and we're trying to bang it out today. So basically, we're trying to bang it out today. Apparently, you guys know the kid I'm talking about? That kid's probably like 30 now. Banging it out today. I'll bang it out all day. I'll bang it for you.
Each individual person.
I'll bang it for me. We'll bang it together. Wait and see. I'm talking about a gavel. Don't unravel. She bangs, she bangs. Oh baby, she moves, she moves. I go crazy. Oh my
Proceed
god.
to sentencing right now on count 2, the conviction for assaulting Mr. Underwood. And in this case, based on the testimony presented today and the verdict of the jury in response to Mr. Underwood's testimony regarding what happened and Mr. Arif's testimony, which is essentially the opposite of what Mr. Underwood stated. I think slugging somebody in the face unprovoked is more than the typical assault we might see in a situation like this. And I think it needs to have an appropriate punishment. I'm going to impose 20 days in custody. I'll give you credit for what I count to be 3 days in custody. I'm going to let you serve those 20 days on or 17 days left on electronic home monitoring. And I will give you until 1 week from today to begin serving that electronic home
Bullshit.
monitoring. So you're going to have to get busy and get that set up.
Will I be able to work?
Yes,
Okay.
that's why I'm putting you on electronic home monitoring. That will leave 344 days suspended, this being a domestic violence charge. I am going to take 5 years jurisdiction on that 344 days. So for the next 5 years, you're subject to the conditions of the court in this case. And those conditions are that you have no criminal law violations, that you not possess any firearm or other dangerous weapon, and that you get a domestic violence evaluation, comply with any treatment. And based on the information provided, there was some concern about the mental health condition on this day. I will require that you get a mental health evaluation. If they say that's not an issue, then that's not an issue, but I'm going to require that you get that. I'm not going to just take the word for it that it's hypoglycemia that led to the behaviors that we heard about today on the 23rd of August.
Ridiculous.
As to the alcohol use, there's some indications that that's an issue, but there wasn't enough by way of testimony for me to say that alcohol played a significant role in the actions on the 23rd. It may have. The testimony wasn't presented other than Deputy Wakefield's statement that there was a slight odor of intoxicants. So I'm not going to order chemical dependency evaluation, but I will say that if that comes up as an issue in either of the other evaluations, then you'll have to get a chemical dependency evaluation. And if that comes up by way of behaviors while we're subject to 5 years jurisdiction, then that can be ordered at that time. So I'll just give you a heads up that that's doesn't mean it's not a possibility, it is. I'm going to put you on supervised probation in this case, so I want you checking in with the probation department within 48 hours. So by close of business on Thursday, the document that we're going to give you today has a phone number. You call them and they'll tell you what you need to do. You report to them as they direct. And you submit the breath test, your analysis test as directed by them. You understand all that?
Yes.
Your Honor,
Ms. Pritikin?
the victim for count two.
We do love Naybell. Thank you, Erica. I went to turn on the oven. I was like, maybe I'll just make a quick batch of brownies on my way to the office, but that can only happen if I get the oven warming up right now. And then I hear the noise from across the room and I think, ah! And I ran to say thank you.
Two would like a post-conviction no contact order. Is that possible?
If that's, I will sign one.
Excellent. I will get that to you then.
As to the,
Chase's mom has the day off today, so Chase is downstairs. Chase came up last night and hung out with me, and I found out that Chase likes carrots. No marijuana in my baking, usually.
no contact orders applying to Ms. Underwood and their mutual child. The state's indicating at this point that they are intending to refile count 1. So those predisposition no contact orders will remain in effect for this point in time. You can always come in and seek modification or rescission on those orders, Mr. Areth, but personally, me, if the issue's before me when you come in, I will want to see that you've made some substantial progress on the treatment obligations that I've imposed that I think are relevant to the issues in this case. So if you want to come back and ask for the no contact order to be modified or dropped, it's going to take me seeing that you're making a big effort to address what I perceive to be significant issues here. So just to let you know what you're looking at. And should have the GNS.
I did have one other question because of the way that this trial is resulted.
Not moving, so you have to move it.
With regard to electronic home monitoring, since the other case in this, since the other count in this case is still open, would there be sort of concurrent credit given toward that charge for any future conviction?
That'll be up to the court at the time. I can't say that. I've imposed a sentence I've imposed. If there is a subsequent sentencing hearing, you can make that argument and it'll be up to the court. That's all I can tell you.
Understood, Your Honor, but so there isn't a concern then about the court applying time retroactively in this circumstance?
I'm sorry.
My concern is that if there isn't an answer to that question today, that a court in the future wouldn't look back retroactively.
I can't bind a future court with their sentencing. There's nothing I can do to bind them. They will, you can make the record, I mean, the record has been made. You can make your argument and the court will decide.
Understood, Your Honor.
Your Honor, can I get a trial date for the other charge?
Oh, so she's refiling. She's gonna do it again. Interesting.
I actually think that's probably smart, so we don't just keep this in limbo. And typically, Ms. Pritikin, this case has been heard on the Wednesday domestic violence calendar.
I'd appreciate that
Confirmation,
if
is
you
that
would
correct?
Keep it.
Okay,
I'll need a trial confirmation in between, but yeah.
I did not expect that. She is fucking tenacious. Tenacious P, the tenacious prosecutor.
okay. I've set Wednesday, the 4th of March. Will you tell me time?
Oh, I'm not available that week.
I'm out of town.
You're
for
gone
the
for
first week
that
of March.
specific week?
No, that's
Yes,
February.
You're back the following week?
I believe so, Your Honor, yes.
Okay, so it'll be Wednesday, the 11th of March for confirmation
That's getting closer to my
at 9 o'clock,
birthday.
and then Monday, the 23rd of March for jury trial, should the matter go forward.
Just 2 days before my birthday.
Thank you, Your Honor.
And
Working on-
let's give Mr. Arith a copy of this order, which now has dates on it.
And I'm working on the post-conviction no contact order.
Yep. I
Or-
won't leave until you get that to me.
But we will. We will leave before you get that to her. Look at this guy. He's like looking behind him like, can you fucking believe this?
Okay, now
Can you
should-
fucking believe this? Yeah, bro, we can. You lost. And she's just giving you literally 0 minutes of break before she's like, you know what? Again. Again. Let's bang it out again. The best thing for him to do, move away. Move away. Send your child support through the portal. I'd be so pissed having to spend all that money on a lawyer and have them do this. Oh. Oh. Anyways, we're not going to wait around. They're going to get that order, and then we are going to say goodbye today. Goodbye. Sorry, I'm trying to collect my thoughts after that horrendous trial. Your daughter is 20 tomorrow. Amazing. Amazing. Tomorrow's gonna be probably 6 p.m. Pacific. A late show. Yeah. That's the way. I like it. Thank you guys so much for being here. Thank you for all of your love and donos and just being you. I appreciate you. Anyways, when is my birthday? March 25th. Only the best birthday of the whole year. I think, does everybody feel that way? I don't know if everyone feels that way, but I feel that way about my birthday. I'm hard to convince. Every year, it's been my birthday. So, I'm sort of partial to it, if you will. Anyways, in the meantime, reminder, I'll be away the first week of February, but we will be coming back to some new, well, knock on wood. I can't even say it yet, but let's just say our schedule might be evening out. We will have the set schedule going forward for shows, so fingers crossed for that. Actually, I would like good vibes coming this way. Do me a favor though, remember that I love you and I'm proud of you, and I will see you in the next video. Okay, bye. Bye.
Ways down red.